State of Utah is now in session. Honorable David M. Connors is presiding.
Thank you. Please be seated. Excuse me a second. All right, we're here in the matter of State of Utah versus Andre Esquivel. Case 1117-01135. It's time set for a hearing on the state's motion to eliminate to exclude certain witnesses from testimony. Do we have appearances for the record?
Nathan Lyon for the government.
Okay. And you are Mr. Esquivel, is that
Yes,
correct?
sir.
All right, thank you. I know for the record it's now 9:40. This hearing was scheduled to start at 9 a.m. We are willing to go ahead with the hearing. This is the state's motion. Mr. Lyon, did you wish to present argument?
Yeah, not really. I think I've outlined my position for the court. Be happy to answer any specific questions that the court may have. My general concern is, Your Honor, is that Mr. Esquivel has chosen to represent himself, which is fine, but he needs to be held to the same standards that a lawyer would be held to. And what I'm concerned about this trial becoming is a free-for-all, where Mr. Esquivel puts on whoever he wants and they say whatever they want, and issues that are not relevant to the case, and I'm concerned about wasting the court's time, the jury's time, and presenting issues that are only going to confuse the jury. And so I've requested Mr. Esquivel's witness list. I've gone through it. Part of my motion for discovery was requesting that the defendant provide for me his witnesses, contact information, dates of birth, and what he anticipates these witnesses saying at trial. And I've gone through his witness list, and to be candid, I really have a hard time making heads or tails out of what these witnesses are going to say. Each witness that he has written down has a short blurb, and then there's a video that's attached to it. And we've gone through and watched these videos, and I don't know if the court's gone through and watched it, but it's these videos that he's posted on YouTube that have been shot with a camera, and it's just, in my opinion, rambling about, kind of this online war that he has going with another individual, this where they're saying nasty things about each other. They're posting stuff trying to prove that X-Tag is a real company. All issues, in my opinion, that don't have anything to do with what we're here to talk about, which is securities fraud, that the defendant made material misstatements of fact and omissions of fact. And we're not here to litigate whether X-Tag's a real company, whether it's been incorporated in Wyoming, or whatever the situation may be. We're here to talk about material omissions of fact and misstatements of fact. That's really the heart and soul of this case. And so, going through these witnesses, and maybe Mr. Esquivel can shed some light on this, but I don't see how anyone is relevant, with the exception of Logan Laws. And even based upon the description the defendant gave, I wouldn't think that he would be a relevant witness, but for the fact that I'm familiar with Mr. Laws and what relevance he might have through an investigation that was done by the state, by the Department of Commerce. And so I know that he might have some relevance, and so I'm agreeing that I'm not asking that he be stricken, but I'm asking everyone else be stricken, because I just don't see how they're relevant.
All right, thank you. Mr. Esquivel?
Yes, sir. Is it okay if I go up?
Yes.
I would like to shed some light. When he says I've been attacked by an individual, by the plaintiffs, for 5 years.
What? I want
He
to make
says an
sure.
individual,
Wait
though.
a second. I want to make sure I understand because there are several references in your descriptions of these witnesses to the plaintiffs. Who do you mean by the plaintiffs?
The 3 men that are pressing charges on me. I've been battling them for 7
The
years.
state is pressing charges on you. So,
Well, I guess your guys'
Who
witnesses.
do you mean by the plaintiffs?
Ryan, Kyle, and Chris. That's what I mean by the plaintiffs.
All right.
But, here,
I
I'll
kind
show-
of assumed that's what you meant, but I just wanted to make sure I understood that's what you
Okay,
meant.
so I've been battling to save our company for 7 years. Okay, it'll come out at trial. That's why I've been wanting trial. But I came last time to my appointment last month with the intentions to ask for a lawyer. The only reason why I keep representing myself, sir, is because Holgi, they keep trying to get me to sign this plea, and I don't want to. I go, show me the evidence against me, and they won't.
Okay.
So I want to see
We've
the
had
evidence
this
against me, sir.
discussion.
That's it. I'll take a lawyer. If he gives me the evidence against me, I will take the lawyer. The plaintiffs for 5 years been saying I scammed old people.
Okay,
hundreds.
hold on a second. We're not dealing right now with those
Yes, sir.
3 individuals. We're dealing with the state of Utah through the county attorney's office. Okay? So it's not a question of what those 3 individuals you named earlier are going to do or not do. Okay, you're standing here representing yourself. You're dealing with the county attorney for the state of Utah. We all would feel much more comfortable if you were represented by a lawyer.
And so would I
We've
promise.
had this discussion a dozen times already, but we're getting close to the trial date, and we don't seem to be making progress. I'm not quite sure how we make progress on that issue. You say you're willing to be represented by counsel.
But they never get me my witness list, the full discovery. It's been 2 years now, and I've never seen the evidence against me. That's why I'm trying to be my own. I filed the motion for it myself, till June 8th. How come I don't have it yet,
June
sir?
8th of what?
July 8th of last month. I filed the motion to have full discovery. So for the last month, I've been going to all the police stations, going through all these police reports, trying to be a lawyer. I've never stated I'm a lawyer. I'm just trying to protect myself because the other 2 lawyers, they were doing things wrong. They were. And it'll come out at trial. So I'll take a lawyer. I'll take one right now. Look, I even got this paper last time. I will sign it. I will take another public defender. But please release that statement so I can show everybody that I didn't scam nobody. Please, it saves me.
When you say please release that
Their
statement,
plaintiff
what do you
witness, the stuff, the evidence against, whatever it's called, full discovery. So I can see what's being said against me. I don't even know.
mean? Okay, Mr. Lyon, has the state provided its discovery package to Mr. Esquivel?
No, Your Honor, and I guess I anticipated this. I've got an email that I can show you. I received an email, I'm assuming from Mr. Esquivel on July 16th, requesting all police reports, full witness list. I replied, I'm happy to respond to any of the questions you have. However, as I've told you and your associates, these requests must come by way of a motion to the court so that we have an undisputed record as to what has been requested and what has been provided. I've spoken with Mr. Esquivel, I've spoken with Mr. Brady on numerous occasions. I'm happy to give. I'm assuming he already has all the discovery, but what has been coming to me
If
is
I do,
we want
Wait a second. Do you have a record of having given a discovery packet to either the prior lawyers that have been involved or to
twice.
Mr.
We've
Esquivel?
given
Okay.
discovery to defense counsel twice.
Okay.
And I am assuming that when these lawyers are no longer on the case, the defendant has a right to the file. I'm assuming the file has been given to him twice. What they're really, the request that's come to me is we would like a witness list. I'm happy to do a witness list, Judge. My problem is I don't want to get in the pattern of kind of these requests coming via email or conversations in the hall, and so we get down to trial, get down the road sometime and say, then we have a dispute over what was said and what was requested and what was given. I won't do it with this defendant. What I've said from day one when he's decided to represent himself, just file your motion with the court so we know, we have a record of what's been requested. We'll then have a record of what's provided, and there's no dispute. I'm happy to do that, Judge. But to date, if Mr. Esquivel has filed anything with the court, I haven't seen it.
Mr. Esquivel, have you filed a request with the court for
Yes, sir, June 8th.
discovery?
June 8th. And
With
then I
the-
filed a motion to dismiss June 19th because I wasn't getting none of my evidence. And I have copies of both. The motion to dismiss was June 19th. I sent you a hard copy through snail mail, and I sent you an
Hold on a
email with
second. You
it.
need to
Sorry.
address me, not him, okay?
I'm sorry.
Can you check to see if there's anything on it?
Just a second. When I pull up the court's record, Mr. Esquivel, I don't see any copies of any of these things that have been filed.
I'll
with the
email
court.
them to Mr.
That's not filing
Oh.
them with the court. You've got to understand that. Mr.
No, I meant
Brady,
the
put
copies.
your arm down.
My copies say filed on it, so I meant I was going to email him the copy so he could see that I did. That's all I meant by that, sir.
There's nothing that's been filed with the court.
Okay, I can send copies. I really did file it.
Mr. Esquivel, I don't know how many
Andy.
times we need to have this discussion. You cannot just continue to represent yourself and
Hey, I'll take-
ignore all of the court's rules. You can't do that. If you're going to represent yourself, you have to learn the rules and follow them.
I'll take a lawyer, Your Honor. I'll take a lawyer right now. I can't. I'm doing this stuff. I'm filing it, and I have it on video. I have copies of it. I don't know what else to say.
Your Honor, can I just express
That's
one
fine,
concern
go
that I have? This will be the third lawyer that Mr. Esquivel is going through, which, I mean, he has a right to his attorney, and I'm not trying to infringe upon that right. He's already had one public defender, and my recollection is after Mr. Albright, I want to say Mr. Fugino was appointed, but I'm not certain. There was someone else in the interim, and he specifically rejected any sort of public defender. And now months have elapsed since the time that he got rid of his public defender, rejected any other public defender, and now as we're getting closer to trial, he's requesting another attorney. And frankly, I don't anticipate an attorney, and I forget what our trial date is. It's September, October. I mean, it's going to be a lot to find an attorney who has those dates open and is able to get through all of the discovery and be ready to go by October. It's just, I don't know what the court wants to do. It's just really frustrating. On the one hand, Mr. Esquivel keeps saying he just wants his day in court, but everything that he's doing contradicts that. We'd like to get this case over with, and we have a right to a trial too. But, I mean, his conduct in the state's opinion is obstructive, and it's kind of delaying. I mean, it's almost delay tactics.
I was here, sir, last month, July 10th, because I thought court was supposed to be and it was canceled. For the last 2 months, I've been trying to get this full discovery. I did file the motion for it June 8th, and I have proof
No,
of it.
you didn't file a motion. You got to understand what we mean by file.
Yes, sir.
By
That's
file,
what I
we
don't
mean
understand. I'm sorry for
You present
that.
it to the court clerk's office.
And she
court
stamped
clerk's
it
office
filed, sir.
Well, they didn't put it in this record,
Okay,
and that does
that's
not
why I
happen.
wanna go back
That
to the
does
state
not
bar.
happen in this court. Okay.
Okay.
So it
Yes,
was
sir.
never properly filed.
Okay, sir. I'm trying. I'm doing it. I did file it. I'm sorry.
Okay.
If I can have the full discovery, then I'll hire my own lawyer. Once I can prove to the company that there aren't these people that are fake. Let me have the full discovery and I'll hire my own lawyer and we'll be ready for October. I just haven't wanted to take money from the other owners, sir. I haven't. I've been trying to do everything right. They've been trying to provide me. There's 14 owners to this company, not just me.
Yeah, but you're the one that's on trial, so I'm not sure what importance it is that there have to
Because
be
of the
14 owners
statements
of
that
this
the
company.
plaintiffs made, sir, and they lied at pre-trial.
Understand, the plaintiffs may be witnesses, but the plaintiffs you refer to are not parties in this litigation, okay? The state is the party. The state has the burden to prove beyond a reasonable doubt every element of its claim. The state does have burdens regarding discovery, but the state has made a reasonable request that you put those requests in writing and file them with the court the way they're supposed to be filed.
I thought I was. So if I could just have that full discovery, I'll go hire my own lawyer. They'll take the case.
You haven't made a request for the full discovery that is recognizable by the court because it has not been filed with the court and presented to the court.
Okay, yes, sir.
When will you make that request? I'm going to give you the chance to do this. It is important to me that we have a fair trial.
Yes, sir.
I do not intend at this point to reschedule the trial. So you're going to be on a very, very short leash in terms of time frames, okay?
Yes, sir. I live
All
here
right.
now. I moved back to Utah.
Okay, by what time, and I'm talking about days, not weeks, within how many days
Today.
can you...
Sir.
Don't overpromise, because I don't have the confidence that you know exactly how to make this request, okay? What's today, Wednesday? All right, by Friday of this week, I'll give you 2 days. You may submit a formal written request to the county attorney's office seeking discovery in which you outline exactly what it is that you want, okay?
Yes, sir.
And you file a copy of that with the court. In other words, it's a motion for discovery that you file with the court. And I don't mean by file with the court, send an email to Mr. Lyon. I mean, you file it with the clerk's office the way it's supposed to be filed so that it ends up in the court's record of this case. Okay?
May I ask just one thing? It's going to help me.
You may ask me one thing,
Yes, sir.
yes.
The paperwork that I filed, I know it didn't get filed, but Mr. Lyon had seen it July 3rd from Albert. He said it was correct. I'm just trying to see where I
Who's
did
Albert?
the correct thing. Alan. Sorry, Alan was here. Alan had showed it. Was that the right thing that he had showed you?
Alan's not a lawyer.
I'm just trying
right?
to find out if that was right.
Alan's not a lawyer,
Yes, sir.
right?
I understand.
He cannot represent you.
Yes, sir. I got it.
Okay. If you intend to seek representation, I assume what you were showing to me was an affidavit regarding your
Well, that was to get a public
financial
defender.
situation.
Yeah.
So that
I can't do that. He said no. Right?
Well, he doesn't make the decisions in this courtroom.
Okay, sorry.
I do. Okay. If you intend to request that this court appoint counsel, then fill out that affidavit and submit it also by this Friday. Okay, by close of business, by 5 p.m. Friday. Okay. You're to file a formal written request for discovery and file this affidavit, and after receiving responses from the state or objections that they might have, because they have a right to be heard as well, then I'll make a decision regarding your motion and your request to have counsel appointed. And what I'll do is we're going to schedule another pre-trial conference on this matter about 2 weeks from now, which we're going to resolve these issues and make sure we can go forward towards this October date as quickly as possible.
Yes, sir.
Okay? And the state, if it chooses to object to either of these submissions that I've asked them to make, and the state certainly has the right to object, but if they choose to object, I'd like that objection to be made in writing and received by me in time that I can review it before this next hearing we're going to set. Okay, so I know it's an expedited time frame, but we're all interested in moving this along. Okay, so August 20th. Is that our? That's our Tuesday, right? Yeah. Well, no, let's do on a regular Tuesday law and motion calendar. Because this is just going to be a very brief hearing where we're going to talk about whether we're going to appoint counsel. Okay, in the morning, yeah. Yeah, so let's do August 20th at 8:30 in the morning. And we'll address that, but I got to see written motions. They have to be filed with this court. They have to have the case number on them, a caption on them, so the clerks know exactly what case they're supposed to put them in. You understand? I mean, those are all rules that need to be followed.
I thought I was following them. I'm sorry. I'll be on it.
And otherwise, I'm going to take, for the time being, I'm going to take the court's motion and eliminate under advisement, and we'll determine as we go forward when we're going to specifically address that. And if I want to address it, it's got to be addressed sufficiently in advance of trial. But I want to sort this out right now in terms of the representation before that. So I'm just going to basically I'm just going to hold that motion in abeyance for a while, Mr. Lyon. Okay. All right, so we'll be back here on Tuesday, August 20th, 8:30 in the morning, and we've got to nail down this issue regarding representation. I'll tell you again, as I've told you before. The court, the trial system is intended to be fair and equitable to both sides. But it doesn't work very well if one side doesn't understand the rules and doesn't follow the rules, and is not represented by counsel. You have a right to represent yourself, but the fact you may have a right to doesn't mean it's a wise thing to do. It's a very unwise thing to do, to try to represent yourself in the face of a complex jury trial with all of the procedures and rules and things that go along with that. And so even though you have a right to represent yourself, I can't state strongly enough that it's not a wise thing to do. If you are finally willing to be represented by counsel, I'll consider that. We'll decide where we go with that, and we'll address that basically in a couple of weeks. Okay?
Yes, sir.
All right, so we'll see you back here August 20th, 8:30 in the morning. And when you get here, make sure you make contact with Mr. Lyon. There'll be 50 other people in the courtroom that morning because that's our felony law and motion calendar. And you've been here before at those, I think.
Yes, sir.
So make sure you make contact with Mr. Lyon so I know when the two of you are ready to go so I can, address your case and move on to the other things. Okay?
Yes, sir.
All right. Thank you. We'll be in
Thank you.
recess.